Janet Sura versus Jimmy's Last Laugh, LLC.
Good afternoon. May it please the court. My name is Phil Georges, and this is my first time appearing before the court on an appellate civil matter. I would ask permission, Your Honor, to reserve 3 minutes for rebuttal.
3 minutes. All right, sir. You may proceed.
Thank you, sir, and thank you, Your Honors. This matter arises out of a much simpler matter than the matter we just heard. This is a trip and fall.
Everybody says that.
Yeah, no, that last matter makes my head spin a little bit. This is a trip and fall that occurred at a hotel, and it occurred because we believe due to the way an area was improperly warned of and cautioned of and kept away from patrons entering a specific area. This matter came up on a motion for summary judgment by the appellee, and the court granted it on the basis that the condition the court found was an open and obvious condition, and because of that, a substantial element of duty was negated because of the open and obvious condition. Now, the reason we brought this appeal, Your Honors, is really pretty simple, and that is because we believe that there is sufficient evidence that should have been considered. The court did consider and looked at the evidence, but we believe that rather than looking at the sufficiency of the evidence, the court really looked at the weight of the evidence. And that's the problem with this particular matter, because with the evidence that was presented under the sufficiency of it, it should proceed to a jury. The motion for summary judgment should have been dismissed. Looking at even the court's order and what the court considered, and which are really the three main things that we considered as the plaintiff's side in this matter. They're really the three main factual pieces that were considered in the statement of facts. It had to do with the closed caption TV evidence, so this whole incident was caught on video. So there's no question as to what happened or that it was Miss Sura or where she fell. That's all on closed caption TV. The second is the photographs that were taken of the scene. And the third is the testimony of both Miss Richter, who is the plaintiff in this matter, and her fiance. At the time, it is Mr. Richter, her husband now, but at the time it was her fiance, and that's why the record reflects that statement. Looking at all three of these items together as we look through them, they raise the issue, which is in dispute here, of whether or not this condition was open and obvious. That is something that we obviously disagree on, and as the appellee points out in his brief, he states, well, just because we have a dispute doesn't mean that it's a disputed fact. Well, I think it's more than that. If we just had a dispute and there was no evidence to support it whatsoever, I would agree that it's not necessarily a disputed fact, or it could be found in a contrary way. In this particular case, though, we're dealing with more than what we deal with in hundreds of premises liability cases on a daily basis. We usually don't even have this much information. We just have the testimony of a plaintiff in a matter and a contention by a defendant that they weren't negligent in the maintenance of their property, and there's no video evidence, there's no photographic evidence at the time, there's nothing other than those statements. And when we just have those statements alone, standalone, well, it's a fair argument to say that maybe there isn't enough sufficient evidence that's material in order to move forward on a dispute or to even show a dispute. But that's not what we have here. The court was supposed to look, the trial court that is, at the sufficiency of the evidence, which is the materiality of the evidence. That materiality of the evidence looks, as case law tells us, at direct evidence and circumstantial evidence that exists. In this case, we have multiple areas of direct evidence. We have actual video footage. We have actual photographs. We also have testimony. And then we have the circumstantial evidence that comes into play that's viewed by watching the video. The circumstances being, did Ms. Richter act in a reasonable way? Well, that's a question for the jury, not for the trial court to answer summary judgment.
Let me ask you a question.
Yes, sir.
Is the video and are the photographs consistent with the allegations of the plaintiff?
Yes, they are.
Okay, so in other words, you can look at the video or you can look at the photographs and you can then take the testimony of the plaintiff and say, this could have happened that way.
Yes,
Okay. There are no inconsistencies there.
not that we see, no.
Okay. Go ahead.
Thank you. So looking at this evidence, we have material evidence. This isn't just some sort of speculative in the air opinion or box saying, hey, did this happen in this manner? No, it lines up. We have the evidence. We also have testimony. That's another issue. So we have two people that have testified in this case that were present, Ms. Richter, the plaintiff, and her fiance at the time. Their testimony is supposed to be weighed by a trier of fact. What are they weighing? Their credibility. Does what they say line up with the physical facts? That's why we have jury instructions of that, dealing with the photographic evidence or the video cameras. Is their perceptions reasonable? Reasonable, in this case, deals a lot with that standard, a reasonable person standard. Did Ms. Richter act as a reasonable person would have under the same and similar circumstances? Again, a factual analysis to be made by a trier of fact, by the jury, not by the court at a motion for summary judgment. The court is supposed to look at these facts that were presented in the light most favorable to the non-moving party, the plaintiff at that time. The court did not do that. The court instead...
Where do your facts and the facts submitted by the defendant, where are they inconsistent? Or where do they differ?
They differ in terms of, where they differ has to deal with a couple of things. One is with regard to whether or not this condition is perceivable. So we believe that based upon even the photographic evidence and the testimony, which coincide, that it isn't a perceivable rise. I know that sounds strange, but even if looking at the photos, in our opinion, you can see that it's not a clear break rise. They contest that, no, you have two different colors. It doesn't match out that way. I know that may sound weird, and that's why even Mr. Richter testified, I couldn't even tell the difference between whether or not, was this a step or was this a continuous rise?
Was there any expert testimony regarding the step of the rise?
There was no expert testimony in that regard. We did have an expert report that we really didn't make any big deal of the expert report in our initial responsive brief at the trial court level. It has come up and floated back and forth. It's not something that I choose to focus on because we did not get an affidavit in regard to anything, because really the experts' opinions went to human factors, which would really be at a trial court level with regard to any contribution by Ms. Richter in her conduct. And that's really why that expert exists, because we believe that the analysis with regard to the perception of the rise, where the rise was located, this essentially walking path hallway towards a window in this area that we're going to call it a planter, even though it's not designated as such as a planter, those are physical facts in dispute. That's for a jury to weigh, and that's why there is no testimony, to answer the court's question, by an expert with regard to that. So with regard to this analysis, we believe that the only way the court gets to the conclusion of an openness and obvious condition is they would have to have imposed their belief in the weight of the evidence. They would have to have imposed their belief in the weight of the credibility of the evidence of the testimony and the weight of the photographs, how they're perceived versus what the video showed, versus whether or not even Ms. Richter could see that it was open and obvious. Because that's the other factor in this, Your Honors, is that it's the common feature. So Tennessee courts have stated over and over and over again, actually in every case that the appellee cites in their brief, all the cases that are cited by the appellee deal with what's called the common feature. Okay, and what that is that the courts have rightfully construed before the appellate courts, that when we're dealing with situations of common features, walkways, stairs, even planting areas or landscaping, okay, outdoors and things that are within the common feature of the common perception, the common knowledge of everyday persons, and there is a condition that's open and obvious in that. So if we have a sidewalk, and we have a rise in that sidewalk, maybe it's only a limited rise, an inch, for example, has been a classic one in the appellate courts have held. Well, that's an open and obvious condition. It's right in their path. They should have seen that, and a reasonable person would not have seen that. And therefore, it's an open, obvious condition. It negates an essential element.
Doesn't that require expert proof, though?
I don't believe it requires expert proof. No. Not to say if it's within an open and obvious common feature. No, Your Honor. I mean, I think a sidewalk is a sidewalk.
You interjected a moment ago, there's an inch rise there, though. So I'm just wondering how that...
I use that as an example because I think it's very clear that the Court of Appeals has stated that a 1-inch rise doesn't give rise to negligence. I think there has to be something more to it than just that in a sidewalk. And that's why I use the 1-inch example. In this case, we do not have a common feature. We have a unique feature, to say the least. We have an area that, as the court can see in the video, the close video, the client comes in, she's never been there before. She sits down at the bench that butts up against where this fall occurs, and then she hears a commotion outside. She goes to look out the window to see what's going on because it's in a vestibule area where the cars are pulled up, is where her fiance is. And when she gets up out of the bench to round that corner, because you can see directly, as the photographs show directly to the window, there's appears to be a walking area. She goes towards that and falls. It's a unique feature. It is strange in design. It does have plants in the other area, not as the court says, the trial court. The trial court says it's filled with plants. The photographs speak for themselves on that issue. Again, that's a determination of weight, we believe, that all of these factors and considerations, even as I'm standing here telling the court right now, Your Honors, go towards then the reasonableness, the reasonable standard of the plaintiff and how she acted, the reasonableness of the conduct of the defense, of whether or not they properly warned of a condition that as a practical matter could not be removed or repaired, as it states in Bowman v. State, 206 Southwest 3D 467. They should have taken action. It was a foreseeable harm in our opinion. I know I'm running out of time. I apologize, this is a new format for me. And we believe that based upon all this, the court interjected its viewpoint by weighing the evidence, rather than by saying, there is sufficient evidence here, there are issues in dispute, there's facts to support both sides. That's for a jury to decide. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. Excuse me. May it please the court, my name is Andrew Grams, and I'm here with my co-counsel, Sveta Todorova-Kelly today. I represent Jimmy's Last Laugh. They are the owner and operator of the Margaritaville Hotel, which is on the other side of the downtown here. We filed a motion for summary judgment on the issue of this landscape area. And let me just picture the landscape area for you. As I am facing you, you have the doors, which are the double sliding door entryway to the hotel with windows on either side of the door. There's a wall with a bench next to it, and past that wall is this landscape area. This landscape area is raised. It's a different color than the floor. The floor is a light beige colored tile. And this landscape area sits under an open staircase that goes from the first floor up to the second floor. The staircase itself has iron steps, metal steps, and it's open so that as somebody's walking upstairs, they could drop something below through those steps. This landscape area is filled with plants. There's no seating anywhere near it, and you can't get to the windows from it. It is not a walkway, but it's actually a continuation as you're standing there facing the doorway of the entrance. Behind me would be the lobby desk. So this is the lobby to the Margaritaville Hotel. We filed a motion for summary judgment on two issues. One, that the landscape area onto which plaintiff fell was not a dangerous condition. And two, that defendant owed no duty to the plaintiff to warn or otherwise remove a dangerous condition. The question for the court here today is whether the trial court correctly ruled that the defendant did not owe a duty to the plaintiff in this case. We reply in the affirmative with the words of the Tennessee Supreme Court in Rice versus Severe, that the duty imposed on the premises owner does not include the responsibility to remove or warn against conditions from which no unreasonable risk is to be anticipated. This maxim applies more so, whereas here in this case, the condition is open, it's obvious, there's no identifiable defect presented in the area on which she fell or in the area surrounding it, and there's no obstruction to the use of any walkways or the lobby areas of the hotel, and where it was not intended itself to be used as an area inviting patrons into it, whether to walk or to sit. Simply put, the raised landscape area does not pose an unreasonable risk of harm to patrons of the hotel. The trial court zeroed in on this question in its opinion, focusing on the foreseeability of harm. Citing Shaw versus Metro Government, the court noted, for the purpose of determining whether a duty exists, the court's consideration of foreseeability is limited to assessing whether there is some probability or likelihood of harm that is serious enough to induce a reasonable person to take precautions to avoid it. Of course, anything that in fact causes harm is in some degree dangerous, but to impose liability, the thing must be dangerous according to common experience. And that was from the Court of Appeals in Henry versus City of Nashville. The Shaw line of cases that the trial court relied upon, which we cite in our brief, Batts versus Nashville, Memphis versus McCready, Henry versus Nashville, and Rye versus Nashville, they all took up the question of when or whether a defect in a sidewalk, a curb, a parking lot on property owned by municipalities were actionable. The cases share the question in common of whether an obstruction or other defect which did not interfere with the use of the sidewalk or the parking lot or the other feature of the property at issue, and where it was not foreseeable that an injury would result from the use of the sidewalk or the parking lot in the exercise of reasonable care, whether a duty may be imposed on the property owner to warn or remove the defect. The cases examined things like a depression in the pavement, a trivial hole, minor defects such as one portion of pavement being higher than another.
Was this a defect or was it a design?
No, it was neither. This was an architectural feature of the property, and there is no defect complained of. You know, the court in those cases noted that, you know, when you're experiencing and confronting a defect in a or a dangerous condition, you're confronting it according to common experience. And if it's a slight defect or something like that, it's not something that would be actionable. Cagle versus Gable.
Do we have
Yep.
disputed facts here?
No, we do not, Your Honor.
Okay, so it's just a question of the application of the law then?
Correct. In our view, it is a question of application of the law, and I will show you the.
So you and the plaintiff both agree on how the injury occurred?
Correct. We
Okay.
we agree on how the injury occurred. We agree on the fact that it's a raised platform. We agree that the color of the tile is different, that there was no defect in the tile. There was nothing. It was simply a matter of, if you look at the video, of plaintiff's inattention as what happened. The trial court actually adopted all of our statements of undisputed facts and its findings of facts, except for fact number 12 and 14, I believe. But they adopted those as material undisputed facts. And the one fact that the plaintiff, the appellant, did dispute is, you know, there's testimony that Mr. Riche says that you can't really tell the difference between the color of the tile and the floor because at night it looks darker. Well, Mr. Richet's testimony can't apply there because Mr. Richet, one, was not an eyewitness to the incident, and the incident didn't happen after dark at night. It happened about 4 or 5 o'clock in the afternoon. And really, Miss Sura was only in the hotel lobby for about 30 seconds before this happened. She walked in, was looking at a commotion outside, walked over to her left, and you can see clearly on the video, she simply walks forward and doesn't look where she was going and doesn't appreciate that there's something there. So it's an unfortunate accident, but accidents happen. And, you know, as the trial court ruled and looked, you know, there was no, this condition did not create an unreasonable risk of harm to patrons, and it wasn't foreseeable that that harm would have occurred in this way. And the court's specific ruling here, which I believe is the appellant disputes, is that, I mean, the court says in its opinion, you know, reviewing the video, the images, the undisputed facts, it is clear that plaintiff should not have walked where she did. It was not foreseeable that someone would walk into an area which was colored differently than the floor, elevated from the floor, and filled with plants. The foreseeability and gravity of harm do not outweigh the burden placed on defendant to engage in conduct to prevent the harm. Simply put, Your Honors, we have put, you know, the testimony of the plaintiff, the testimony of her, I guess now husband, Mr. Richet, into evidence. We've got the photographs, we've got the video, all of which are consistent with the facts that are outlined in the statement of material facts. And to be clear on those facts, plaintiffs actually agreed with all of the facts. There was one where they expressed a disagreement, but it was only in a disagreement on the fact that Mr. Richet says that the tile and the color of the tile and the color of the raised planter look, you know, similar at night. But that's not a dispute of that particular fact, which is that they are different colors and contrasting colors. And we also showed Mr. Richet's testimony in the record where he admits that they are two distinctly different colors, one brown and one mustard. You know, and to address the issue of the evidence at the summary judgment stage, you know, the non-moving party must respond by affidavits, depositions, answers to interrogatories, and admissions with specific facts showing that there is a genuine issue for trial. No additional statement of material facts was filed showing that there were any other facts or any facts that were in dispute. The trial court at this stage simply looks at the evidence that is put into the record, and it looks at whether the evidence answers questions and settles a claim or negates an essential element of a plaintiff's claim, or whether it leaves questions open. And in this case, the court had a very well-reasoned and thorough opinion and findings of fact and conclusions of law, which shows that based on the evidence that's presented in the record, no material dispute of fact exists, that no material dispute of fact exists, and that no duty was owed on the part of the defendant to do anything to either warn of this area or to remove it. And there's been no countervailing evidence to suggest, admissible countervailing evidence to suggest that the defendants acted improperly or had any reason to believe that there was a danger here to the public and patrons of the hotel. We submit that the trial court's ruling should be affirmed and that it was proper, and we ask you to enter an order ruling, upholding that ruling. Thank you.
Thank you.
Okay,
Is
so-
there any showing of prior injuries in this area?
Does the plaintiff have prior injuries?
Yeah, did you have any showing of prior injuries in this area?
No.
As a result of that?
Not that was answered, no, Your Honor.
Following up with that, I'm looking at the trial court's ruling, and it says, it was not foreseeable that someone would walk into an area which was colored differently than the floor, elevated from the floor, and filled with plants. Any of those issues disputed?
Yes.
Besides the foreseeability, I'm talking about the objective things, that the floor was colored differently, that it was elevated from the floor, and it was filled with plants.
It had plants, it was not completely filled with plants. And that actually was in.
Besides that, I mean, it had plants in it, was colored differently, and it was elevated. Is that accurate?
It was colored differently, that is accurate, and it was clearly elevated because she tripped over it, yes.
Okay.
But with regard to the plants, which actually is a substantial feature of this thing, kind of going through a couple of things. So with regard to the foreseeability that Appelli talked about, he mentioned, again, completely filled with plants. This is not a landscaped area, by the way. This is a strange like planting that has been done by the stairwell, which again also encompasses a feature where they're open so you could drop something down, which then begs the question, if you could drop something down, then obviously you could get behind it, which you can get behind it because of the walkway, which is where Ms. Richter went. Because, I mean, I myself even went there and walked right up the walkway to the window, under the stairs, around. I mean, it is not a closed off feature that is not accessible to the public. That is not what this is, and the photographs demonstrate that. In addition, you know, we have gotten to the point, I think, here where we agree on several things, but we did dispute some of the facts, actually 3 in particular. It was number 5 in the statement of facts. We disputed the fact that the plaintiff decided to sit down and began walking forward when she hit something or brushed something. We denied that, and then we also then stated and pointed to the closed camera video footage as support of our position of how she tripped over the planted area. Number 8 and number 10. Number 8 deals with the landscaped area as not being flush with the lobby floor. We agreed that it was not flush, but we disputed and denied that it was open, that it was not obvious. And then we pointed to several excerpts of the record to demonstrate that. And again, in number 10, we denied outright. The floor by landscape area is made of a light colored tile leading to brown. To the area, we disagreed with that description completely. And again, yes, to go to your point in your question, Honor, is there a differential in color? Yes. Does that differential color help the eye to differentiate the rise? No. And that is a consideration for the jury, we believe, to decide and to take a look at. And we do think that that is in dispute.
Okay.
Any other questions, Your Honors? Thank you
Thank
for your
you.
time today, sir, and ma'am.
We appreciate your briefing. We appreciate your argument. We'll take this matter under advisement and attempt to render an opinion at the earliest possible time. That concludes the call of the docket for today. We'll stand in recess to the call of docket in the morning.